defendant would be required to establish either one, that it did not serve alcohol to assailant while visibly intoxicated, or in the alternative, the sale of alcohol had no reasonable or practical connection to the assault. Neither were met here, though. To be clear and extremely important, respondent's brief arguing that respondent's employees state, and I'm going to quote the brief, the night in question, no one was served who was visibly intoxicated and no one was served to the point of intoxication is in stark contrast to fact.
Counsel, why can't we consider Mr. Croom's testimony, at least the portion that we have, the 9 pages that we have, why can't we consider that as sufficient evidence for them to meet the prima facie case?
Well, respectfully, it's not, though. If you actually examine Mr. Croom's testimony, Mr. Croom talks about how generally he does rounds. First off, he's a bouncer. He's not a server of alcohol. He tends the door. But he does testify, yeah, my general habit is I'm going to walk around the bar. I'm going to look for intoxicated, I'm going to look at the crowds, basically. He doesn't actually testify relative to our party, the group, or the events at issue. What he says is, yeah, I remember the day in question. Notably, he is the only person that remembers the day in question or its patrons. Miss Brady did not. Our record at page 76. Do you remember any patrons? No.
Right.
Miss Taylor? No.
Right. I agree with you as to Miss Brady and Miss Taylor. We only have 1 page each from theirs. I'm looking at page 80. He has this question during your post on September 29th, and during your post means I was outside as a bouncer, not really inside. Did you at any period of time watch any of the patrons inside? And then he says, he gives kind of a longer answer. So from time to time, if I had a slow moment, I would like to do a quick round. And if someone may have appeared, we would signal the bar. So he's talking a little bit more hypothetically. He's using that kind of phrasing. And then the question's then clarified right after that. Was that a typical habit of yours, or is that something you did on the particular night I'm talking about, September 29th, 2018? And then he says, no, just in general, while providing security there at Poise. So it sounds to me that that response all goes to sort of his general practice.
But that's my point, Your Honor. It is his general practice.
Just a moment. Then the next question was, did you do any rounds on September 29th?
And he says, yes. And he actually recalls the night and he calls it a slow night. And he says, yes, I did rounds on that night. And then, I'm summarizing here. And then they go on to say, how many rounds? He says, I can't remember. Here's the important part, though. He doesn't say he did rounds while the party or assailant in question is there. So just because he did rounds at 5 p.m. doesn't mean he can attest to anything that happened or rebut appellant's position here. So yes, he does testify the day in question was slow.
He testifies too that essentially his responsibility is, as he does these rounds, if there are intoxicated people, he's supposed to get them out of the bar.
I think he goes on to also say, though, that, we allow them to police themselves relative to intoxication.
Right. And he says, and he's asked, did you have to take any action that night? And he says, no, there was nobody that was visibly intoxicated, my view, that night. That's the testimony that he gives.
Absolutely. He says, according to his rounds, we can't say when they were done. We can't say how many were done. But yes, during those rounds, which we don't know when, I didn't see anybody. That's not enough, though. See, we have appellant and we have Miss McCowan saying, look, we were intoxicated before we got to that bar. We were, in fact, disallowed into a bar.
Well, that's a different issue because he says, I was at the door and I didn't let anybody in who was intoxicated. That's his testimony.
That is his testimony.
Right. So there's 2 things that he says he was involved with.
Respectfully, I think it runs contrary, though, to appellant and Ms. McCowan's testimony that say, look, we were all intoxicated. The entire group were denied access.
Just a moment, though. That's the other side of the argument. That's after the defendant meets his burden as to whether or not there's a question of fact here.
Certainly.
Right.
Assumingly so that this court were to accept that the respondents met their burden. I still think, though, that appellant properly raised a question of
fact. But just to be clear, you're not saying then every bar has some responsibility to track specific patrons so that if a lawsuit is brought some years later or depositions are done years later, that anyone in that establishment is to remember the patron. Remember, I saw him or her at the bar and they were there, but they weren't visibly intoxicated as we were serving them. Is that the standard that the defendant has to meet? Is that how you're articulating the defendant's standard?
I think if you were to grant summary judgment, certainly, but I think there are tribal issues of fact in this case and in any case that you were to have parties that say, look, this person was intoxicated.
I understand that part, but the defendant to meet his burden doesn't have to go as far as what I think you're articulating here, that you've got to specify any particular patron in that bar and that person was not visibly intoxicated every time that they were served a drink.
I don't think they can generally assume, since I, singular person, didn't see it, it didn't happen. I don't think that warrants summary judgment. But if you were to accept the respondents in this case met their burden, I do think properly questions of fact were raised that warrant denial of summary judgment here. Certainly, I think, obviously, I'll submit that the appellant's testimony is unrebutted, that the assailant was intoxicated prior to entry at respondent's bar, that they entered respondent's bar, they consumed more alcohol at respondent's bar, assailant was intoxicated after respondent's bar, and obviously assailant assaulted plaintiff.
But nobody singles out and says the assailant appeared to be intoxicated.
I would actually disagree. I think the record actually indicates that that is what the appellant says. Looking at page 249 of the record, that plaintiff appellant says that she knew Houston was drinking at Poise, that record 265, that all of the party was intoxicated when they entered respondent's bar, all of the party, the entire group, including Miss Houston, the assailant.
She's a subset of the group, so that's where you find that that's sufficient.
Well, yeah, because she specifically says it is the entire group. She doesn't just say it's some of the group.
Counselor, where I'm struggling on that is there's a question on page 264. Question to your client. But is it fair to say that you cannot testify under oath that you saw her being served beyond the point of intoxication? Answer, that's correct. So when it comes to the assailant, there's some missing proof here as to trying to establish a question of fact, isn't there?
I actually would disagree. I think this court in the McGillivray versus Barron matter, actually this court, I would take, puts up the position that we don't need any direct testimony from any specific person that says, yes, testimonial, I saw this intoxicated person served additional drinks. In fact, I think what the law says and what this very department says is that it actually can be proven by circumstantial evidence. And here I think there's ample circumstantial evidence to support appellant's claims.
Along those lines, is there any evidence here that she was stumbling, that she was displaying some indication she was glassy-eyed or anything else in the record? Other than, I mean, they all been drinking all night long, no doubt about it.
Yes.
But what's the evidence in the record that the assailant was visibly intoxicated while at the defendant's establishment?
I would argue appellant testifies to that. Ms. McGowan testifies to that. The police even testified to that, saying, look, the group was intoxicated or the persons were intoxicated. Now I will concede, obviously, that officer, whose last name I'm not even going to attempt to pronounce, I apologize. He generalized states, yeah, they seemed intoxicated. But it's actually Ms. McCowan and the appellant that specifically cite to Ms. Houston being intoxicated, talking about how, immediately leaving the bar, she's falling over, they were dancing on the limo bus and such. Obviously, the fight breaks out thereafter. I think there's, again, ample circumstantial evidence to support, obviously, appellant's claims here. If you wish, I'll just wrestle and bounce my papers unless this court has any other further questions.
The only thing I'd ask you to do is to comment on the further part of Mr. Croom's testimony on page 85. I'm going to ask opposing counsel about it, so I'll give you a chance to ask you about it as well. Can you specifically recall patrons consuming alcohol on September 29th at Poise? And the answer is, I was at the door. And he previously had talked about really his job as a bouncer. He's normally out front, aside from these occasional trips in, and we don't know when he did it that night. And you've argued that he hasn't shown that he did it that night at any time when these folks were there. So that he really didn't perhaps do it, that they haven't demonstrated that he did it while these folks were there. Anyway, he says, I was at the door. You said, I'm sorry, what? He says, I was at the door. So that answer is no. And then he says, yes, I've seen multiple patrons eating food and dinners when they order from Poise drinking drinks. Now, if there's alcohol in the drinks, I don't know. And then you ask him about shots, and he doesn't recall anyone drinking shots. Orders of shots for groups. And that was essentially it. He says it was 4 years ago, and that's it with his testimony. Is that the problem? The fact that he didn't see the group, or is it
Well, yeah, that's not rebutting appellant or Miss McCowan's testimony. That's my whole point. These are general statements he's making, his habit. Again, I'm conceding. He absolutely says on the night in question, he recalls this specific night being a slow night and that he did rounds. The problem, though, is he didn't go further to say, and my rounds were conducted while the assailant and her party was there. That is not the testimony. So I think it's quite improper for respondent to put forth before this court that there's evidence, again, that the night in question, no one was served who was visibly intoxicated and no one was served to the point of intoxication. That just simply isn't the evidence before this court.
But now we would then put a burden on any bar moving for summary judgment in a dram shop case to say, you've got to identify somebody who is there with the group and you've got to remember the group. We have to put that, does that burden exist for bars, or can a bar say, look, we don't remember the group, or we can tell you nobody was visibly intoxicated that night, but we can't specifically remember that we have a busy business here. We can't, do you understand the dilemma that we're looking at?
Oh, yeah, but I'm actually relying on this court's decision in Dubell versus the Forks Fire District, in which that's what this court respectfully puts forth, that the moving defendants needed to establish that in order. That relative to these dram shop acts, that's what you're required, the 1 and the 2, either that you did not serve alcohol to assailant who was visibly intoxicated, or that the sale of alcohol had no visible or practical connection to the assault. And I argue nothing here is met, and that simply, we don't even need to consider appellant's arguments relative to the questions of fact that I submit exist, because the initial burden was never met by respondent in this action. I'm respectfully asking this court to obviously reverse the trial court's decision and allow this claim to continue.
Thank you, counsel.
Thank you.
Mr. Cohen?
Good afternoon, Your Honors, counsel, may it please the court. There's no question that this party bus took a number of stops. They went to a liquor store to purchase alcohol. They brought alcohol into the limo. The limo had alcohol. They went to the Niagara Falls Casino and drank. Then they went to the Golden Nugget, and then they came to Poised. There's no question that after they went to Poised, that an individual, Sharita Houston, at 3:16 in the morning at the intersection of Genesee and Gray Streets, which was not on our premises, that she was convicted of this, assaulted the plaintiff, the appellant. And she was charged criminally, and she pleaded guilty to felony assault in the 2nd degree, and was charged as an intentional act, not as a DWI, not as a VTL 1192 crime, and nor was it alleged to be the result of negligence caused by disinhibition due to intoxication. The trial judge was the motion judge, lower court, Justice Sywick.
Mr. Cohen, I'd like to refocus you a little bit on the main issue that your opposing counsel has spent a lot of time with us, and that would be the burden of proof. That the bar's burden of proof in the first instance, and whether that was met. And particularly, did they disprove that the tortfeasor was visibly intoxicated?
Well, Simon Courtroom, the bouncer, security guard, testified truthfully, and he's a professional bouncer. He's licensed, he's registered with the Department of State, and he testified truthfully to what his custom and practice was as security. And no, back to what Judge Nowak with your co-justices were talking about. They can't be remembered in a busy bar to remember specific people on a specific night. He truthfully testified to what his custom and practice was, and he remembers that specific night, and he remembers that there was nobody who was served who was visibly intoxicated. Otherwise, he would have interacted.
Mr. Cohen, counsel, we have a case from 2017 that the plaintiff cited, Sheehan versus Gilray. And in that case, this court ruled that the owner met their initial burden on the parts of their motion by submitting deposition testimony of individuals who had interacted with the assailant prior to the accident. And none of them had a recollection that the assailant was intoxicated. But it seemed that back in 2017, we required some sort of interaction, at least an interaction between somebody from the bar. And of course, you could also use people in the party. You could say, well, you know, the folks that were there in the party, we took their testimony and they don't remember them looking intoxicated either. So of course, how could our staff? You could do it that way too, but that didn't happen here. Here, all we have is Mr. Courtroom, and based on Mr. Courtroom's testimony, and we've been reading parts of it, you know, what he says hypothetically, what he says specifically, but it doesn't sound like he remembers anybody in the group. And so the question I have is, does he need to interact with them in the group, and is that the appropriate test?
That would depend upon how Your Honor wants to define the word interact, or how the law defines the word interact. I would suggest that walking through the premises and visualizing them and making a determination that there was nobody there who was being served to the point of intoxication, that is sufficient interaction under any standard. Whether Mr. Courtroom actually interacted with any individuals is unknown, but what is known is that Mr. Courtroom, an experienced, seasoned bouncer, security personnel, has a custom and practice of interacting and getting involved or intervening, which would be a higher level of interaction, be intervening. If someone's intoxicated, he'll throw them out. And he made his assessment.
No, I get that. The reason I guess I'm asking is that if you accept the plaintiff's version of what occurred as true, which we have to, then they were served up to 7 rounds of shots. Their group was served up to 7 rounds. There's people that do that. There's people that pour those shots and hand them. So there are people interacting. We know it's not Mr. Courtroom because that's not his job. He's a bouncer. He's not serving drinks. But there are people, and if the bar chooses to have no record of who was working that night, no security cameras, no handbook, nothing. If the bar says, look, we're not gonna expose ourselves by having folks that actually did the interaction be identified, can the bar still meet their burden for summary judgment by bringing out a bouncer that was at the door and may have come in when they weren't even there, when the group wasn't even there?
Judge, your hypothetical is interesting, but we don't have to get there. We did produce Tanisha Taylor, Lillian Brady, as well as Simon Courtroom. We produced the people who worked that night, who did serve whoever was there that night. And all of that testimony was before Justice Sywick. Her Honor examined it. She reviewed it. She also looked at the totality of the circumstances here when when this accident was not even attributed to alcohol to begin with. And I think that the trial judge has the right to do that and the obligation to look at a case, accepting everything that the appellant says as true, the opposer of summary judgment. Her Honor looked at it. She looked at the deposition testimony of Tanisha Taylor, Lillian Brady, and Simon Courtroom. She looked at the testimony of Officer Nicholas Kalzinski, which was speculative at best. And he said, the officer, which I think is Ms. Pemberthy's the appellant's strongest argument, is question, and when you arrived at the scene, did some of those people appear intoxicated? Answer, I believe so. That was recorded page 338. Further, he said he didn't have any reason nor did he come across any information to suggest that Sharita Houston became intoxicated at Poise on that evening in question, the record at page 377. So there is no evidence that this was an accident that was caused by anyone's intoxication, and Justice Sywick saw that. And I'm not looking to shift the burden, Judge, but when there is no evidence to suggest that this is even a dram shop action or that there's dram shop liability, Her Honor then took a look and said, okay, well, these people were obviously intoxicated before they got to Poise. They all left Poise, got back in the bus that was the limousine that was filled with, stocked with alcohol. And then there was an intentional tort by one of the partygoers that had a beef with the appellant who ran her over with a car intentionally, for which he was criminally convicted. The elements of dram shop liability against Poise, also against any of the other individual defendants, as far as I can tell, except for Sharita Houston, don't exist here. The altercation took place over 7 miles from Poise, beyond the premises that we are responsible for. And appellant attempts to offer the affidavit of a party goer, Shanika McGowan, but Shanika's testimony also doesn't state or even suggest that Poise had served Sharita Houston while she was visibly intoxicated. And that's in the record. It's cited in my papers. And sung upon by Sumapkan versus Bronx Lebanon Hospital that's cited in my brief, First Department 1995, held that rank speculation is no substitute for evidentiary proof in admissible form that is required to establish the existence of a material issue of fact and thus defeat a motion for summary judgment. That's what we're facing here. Appellant herself testified that she was not sure how many drinks Sharita Houston consumed while at Poise, that she had no basis for asserting that Sharita Houston was served beyond the point of intoxication at Poise, and she does not know the source of Sharita's intoxication, and that's the record at 246 to 249. Proof of mere consumption of alcohol is never enough to defeat a motion for summary judgment in a dram shop action. And I said never, but the Pizarro court says consumption of alcohol is not enough, not never. Pizarro versus City of New York, Second Department, 1992.
We understand, Mr. Cohen, that there needed to be some proof of visible intoxication, okay? And you're saying that on this record that we have enough to affirm the summary judgment ruling of Judge Silent. Is that right?
That's correct, Your Honor.
Okay.
And for the balance of my arguments, unless the court has any questions, I would rest on my papers.
Thank you. Thank you very much.
Thank you all.
Okay, case number 752, Withers versus Robles. And you're both here. Okay, in person. All right, counsel.
Good afternoon, Your Honors. May it please the court. This case presents a question of what's a logical inference. I was backing into the garage from the, my heel caught something. I landed inside the garage. I told the respondent I tripped in walking into the garage. Could those allegations, taken as true, support the logical inference that the appellant tripped on the ledge of the garage, which she identified in her bill of particulars, the very same ledge which the respondent identified in a photograph during her deposition as being in substantially the same condition as on the day of the accident? We argue that it could.
So
Respondent,
what we have a gravel driver. And so she's going from gravel to a concrete, a garage floor. And that's where the accident happened, right?
that's the allegation. Yeah.
Okay.
The argument in response is that this is speculation. But why? In the respondent's brief, there's two facts alleged. She lived there 5.5 months before, and she continued living there 2 months after the fact. What can we draw from those? What inferences could be drawn from those facts? Nothing helpful for the defense with respect to how long she'd been there before. I suppose the argument is you should have known the condition of the entryway to the garage, in which case you're conceding the existence of the condition. And with respect to the 2 months after the event at which she resided there, but according to the respondent's brief, failed to go down there and examine it for further information. It concedes that you could go after the fact, examine the evidence, and come to some sort of conclusion about causation. The respondent is the one speculating when she argues that, hey, maybe you tripped on your own foot, and if you don't agree, that's speculation. The case law on this issue is somewhat confusing. I spent a lot of time trying to draw some line that would connect them all to it. And I regret to say I kind of think I landed on it in anticipation of this argument. There is a case out of the Second Department that's not in any of our briefs, but which I think is informative to how a defendant who is in possession of a transcript such as the one that is the subject of this case has some ways in which they can proceed. You can proceed to say there's no evidence of any condition whatsoever, and thereby say no liability, no condition. You could also base that argument on no causation. There's all sorts of reasons you might have fallen, and because you haven't sufficiently reduced the potentials, you're subject to summary judgment. This court has never adopted the harsh language of the Second Department, which says, look, where it's just as likely you might have slipped on your own shoe or your own foot, you're out of luck. This court's never done that. This court articulates the standard that a plaintiff needs to have enough facts to allow a logical inference to say, you could read these facts and come to some conclusion without having to speculate. Maybe you tripped on yourself, and come to a conclusion about what caused the injuries to the plaintiff. If there's no further questions, I will give you the citation to that case I referenced. It is the Toro v. McComish case out of the Second Department. It's very recent, 227 83rd 1120. I'm hesitant to bring up Second Department cases, but I think that's a case which really articulated the nature of you have a choice of which way to proceed. And below, this case was argued on no notice. Causation, though present in the brief here, is not supported. And the plaintiff has, by the submission of her testimony and her identification of those facts, which I referenced at the beginning, rendered other causes sufficiently remote to allow a jury to come to a conclusion based on those facts and not just guessing. Thank you, Your Honor.
Thank you, counsel.
Good afternoon, Your Honors. May it please the court. Tamara Harble here on behalf of respondent. Before Judge Devlin and on this appeal, counsel continues to argue that the photo of the entrance to the garage, which I think is completely mischaracterized as a ledge. I mean, the photo speaks for itself. It's not a ledge, but that sufficiently raises a question of fact as to the possible cause of plaintiff's trip. We submit it does not for two reasons. First and foremost, I think the photo speaks for itself. There's not a ledge there at all. It shows the demarcation between a stone gravel driveway and a garage. But more importantly, this is not like the Fourth Department case of Dixon versus Superior Covers. In that case, the court, I believe, found a question of fact, even though plaintiff couldn't say specifically what caused her to trip. She testified that she fell in the immediate vicinity of an elevation difference in the pavement. In this case, plaintiff could not and did not testify to where she fell in relation to the entrance to the garage. Specifically, I'd call the court's attention to the record, page 64, and I'm going to read it. Question: in relation to the entrance of the garage, where the driveway meets the garage, do you know where you caught your heel? Answer: I do not. Question: do you know what you caught your heel on? Answer: no. I understand that there's many cases out there from the Fourth Department that says, even though you can't say specifically what caused you to fall.
Right, but she's bringing a handcart, going backwards into the garage, and she falls.
She does.
She's not wearing heels. That was
Correct.
obviously fetted out. It was boots, I think she said she had on.
Correct.
So even though she can't point exactly where she fell, she knows she fell backwards. She knows that it was kind of in the area. She lands in the garage. It wasn't like she landed outside in the gravel. I think she even landed on a lawnmower, right?
She did. She testified that what her testimony was is that as she was pulling the handcart backwards, her heel, again, not a shoe, but the back of her foot, got caught on something. And as she was stumbling back or trying to catch herself, she's now in the garage and she trips over like the chute of a lawnmower. But I appreciate your query, but you can't discount the fact that I specifically asked her where in relation to the entrance of the garage did you catch your heel? Do you know? I do not know. There's grass, there's gravel, there's a condition of a driveway. To suggest when she was very specific that she can't say where she fell or where she first caught her heel in relation to the entrance of the garage, I believe it's pure speculation to find that, well, there's a question of fact that maybe she could have caught her foot in that area. That's not her testimony. Her own testimony is speculative as to what caused her to fall. I think that Judge Devlin got it right. This is a case, although it's not common, counsel could have asked his client questions at deposition. He could have asked her more specifically, here's the entrance to the garage. Were you maybe 2 inches when you first felt your heel? Were you maybe 3? Were you maybe right on it? You know, if he would have asked that and maybe if she would have said, yeah, I think that might have been where I was, we wouldn't be here today. But that wasn't asked. The record before this court and this division shows that she has no idea where she fell in relation to the entrance of the garage and what caused her to fall backwards.
Thank you, Council.
Thank you.
Okay, matter of Cynthia M, case number 753. It looks like we're waiting for one more person. Okay, Mr. Monahan. Okay, so you got the distinction of not only being the last case of the day, but the last case of the term. So we're done when we're through with you, and I appreciate you patiently waiting to have your chance to have your say today. So, okay, with that, Council.
Good afternoon, Your Honors. May it please the court, Torrey Schoonmaker on behalf of Chautauqua County Department of Mental Hygiene and Social Services. The family court decision lacked a sound and substantial basis in the record and was against the weight of the evidence to the extent that the family court held that there was no neglect on behalf of respondent mother or with respect to a number of theories raised by the department. The record, as Your Honors know, is voluminous. I won't go through it in detail. I'm sure the court is familiar with the facts. But the record was replete with evidence of neglect in many forms. The evidence itself taking the form of corroborated statements from the children, medical, dental, and educational records and testimony. Testimony from a maternal aunt, testimony from, I believe, 6 caseworkers that had direct contact with the family, and then a couple of supervisors who really testified on a tangential issue of the credibility of one of the caseworkers. And throughout all of this, I would note that the respondent mother does not materially disagree with our summary of the facts in our appellant's brief. They do make comment that there should be more in there. Respectfully, we reached the word count limit, so we couldn't really put any more in there. But we think that the pertinent facts are set forth clearly in our papers.
There's many things that the parents did together.
Yes.
Okay, right. I mean, so I think you're saying it's pretty hard to come to the conclusion that one of them acted in a way that was neglectful and the other sitting side by side, you know, sometimes in a vehicle with lots of children in it with them, would not also be considered neglectful.
Yes, Your Honor. And I think the family court tried to avoid reaching that complication by only finding neglect in the form of domestic violence from respondent father.
Oh, no, the record has a lot of other instances.
Absolutely agree with you, Your
Of
Honor.
neglect.
And the court basically said the mother did not contribute any neglect.
Correct.
Of anything involving the children.
Right. Family court found that the department had not established neglect in the form of drug abuse, medical and dental neglect, mental health neglect, or educational neglect, which we've gone into detail in our briefs and the evidence that is established. I would like to address a few things raised in opposition. I know our reply brief was very recently filed, so just wanted to point out some things. In opposition on the drug abuse issue, one issue that's raised in the respondent's brief is the contention that there is no nexus between the drug use and any harm to the children. There's plenty of evidence that it did affect the children, but I would emphasize the cross-corroborated statements of 2 of the children that respondent mother sold food stamps to buy drugs, and as a result, there was sometimes no food in the house. At a minimum, I think that would establish the drug abuse had a nexus to some neglect. There are other just medical evidence and the behavior, erratic driving and leaving the children with potentially a stranger during the trip when they left the state. With respect to medical and dental neglect, family court and respondent mother rely on the aspect of those claims of that theory with regard to whether or not there was a financial or other reasonable means to provide the medical and dental treatment. I would just emphasize that the children were on Medicaid with one hiccup for one of the younger children that was really the result of of the respondents not being diligent in obtaining the birth records for that child. They couldn't obtain Medicaid until shortly before the removal. But the other children, they were all on Medicaid. Medicaid would have covered both the medical and the dental. And there was testimony that
So there was a financial resource available for the dental care, but the fact that
Yeah.
I think there was testimony too from one of the dentists that wasn't necessary to have the records from previous a doctor or previous visits in order to treat the ailments that the children had.
Correct. Yes, Your Honor. And some of the, I would also point out that there were some outstanding medical bills, but they were paid for by the children's grandmother. So I think that's a reasonable means that was sort of proven to have existed. With respect to mental health neglect, despite having a child in the home who had a history of self-harm and hospitalization, the respondents failed to secure both firearms and hunting knives, despite being asked by the department on several occasions.
Cut you off a little. We know, we've read this record.
Of course, Your
We
Honor.
know what the actions are. I think your argument, though, needs to be, the mother wasn't part of this. And we have to decide whether through all these allegations, whether mother was free from neglect. I promise we'll do that.
Absolutely, Your Honor. I will say that there was some testimony about the firearms belonging to respondent father, that there's no reason why respondent mother could not zip tie a cabinet that had no lock on it or put away the hunting knives either. With respect to education, the respondent mother's conduct is specifically important for education because of the testimony that she was keeping older children home from school to raise the younger children and take care of them. And that falls squarely on her.
We do have your argument about that the mother is also neglectful under the law, if that is mom is.
Yes, Your Honor. With respect to the recusal issue, I don't want to go into too much detail. I think it's outlined in the briefs. So unless there are any questions about that, we'll rest on our papers.
Thank you. Okay.
Good afternoon, Your Honors. Mary Hoydu. I represent two children. One of the oldest twin girls, she's nearly 17, and the youngest 15-month-old. I too will rest on my papers with regard to the neglect. I'm here today to give you an update with regard to the two children that I represent. With respect to the almost 17-year-old girl, she's doing very well in the care of her maternal aunt. She is a senior in high school. She also attends the BOCES program. She's on track to graduate this spring and is considering trade school after graduation. She is not related to the respondent mother by blood or marriage in this case. And so I would expect that she's going to remain where she is and go on with life and do well. With regard to the 15-month-old, the 15-month-old remains in the same caregiver arrangement. It's a 1017 caregiver arrangement with an Amish family that is located 3 miles from the residence of the parents. The parents are still together, have been together throughout this case. It is troubling to me. I do not believe that the 15-month-old has a bond with either parent. Unfortunately, there has been very, very little contact since this 15-month-old was 2 months old. The Amish family that is taking care of this little girl has an open door policy for visitation. And they have made it clear, and I have made it clear on many occasions, the parents are free to visit every single day. And unfortunately, I know that they've seen this child only 2 times in the last 4.5 months.
Is there transportation issues here?
There are not. No. And
So it's 3 miles away.
it's 3 miles away, and
If they can walk.
the Amish family is actually friends with the maternal grandparents with whom the parents live. And as you know, Amish don't have vehicles. So the Amish family actually relies upon the maternal grandparents for transportation. And so no, there are no such issues there.
And your position is?
My position is that the decision should be reversed. I think there was more than adequate proof of neglect on the part of the mother, and I would ask that this go back for a dispositional hearing. Thank you.
Afternoon, Your Honors. Please the court. My name is Beverly Ungerer and I represent the almost 17-year-old twin sister of Ms. Hoydu's client. Initially, they had separate positions and so they were assigned separate counsel.
Are they residing together?
Yes, they reside together with the maternal aunt as well as one of the other children at this point. And again, I would rest on the brief that's been submitted on behalf of them. I also believe that there was not a sound and substantial basis for the decision that the court made and asked that this court reverse that decision. I'd also like to offer a brief update on my clients. My 17-year-old client is doing very well. She wishes to express her love for her father. She has no love lost with the respondent, or Emily W. She does not like being in foster care. She does not like being a foster child. For a 17-year-old girl, to have to answer to someone every day, this is something that's very important to her and that she has expressed often in her permanency hearings. And we've had many conversations about that, but she does want to continue where she is with the maternal aunt. She's also attending school regularly, is doing well in school. She was in danger of failing when she was brought into foster care. She was one of the first two children to be brought into care. She is doing well. She's also in a cosmetology program through our BOCES and even intends to continue with a course of college once she is out of care. My second client is a young man who just turned 12 years of age. He was 9 when he entered foster care. He has maintained all along that he wants to return to his mother. He is the only child that is not fathered by James M. He has a separate father who has not been involved in these proceedings nor in my client's life to any significant extent. He does want to return home. I've had this discussion with him a number of times. He's remained steadfast in that. I've explained to him, the court's position, and it's my duty and obligation to express what he wants to the court, and I'm doing that. I'm also, and I've addressed this in, I think, prior briefs or papers, that I am substituting judgment on his behalf because I feel that he would be at imminent risk if he were returned home. He had missed significant amount of school, and that is all in the record. Prior to his entering foster care, he attends school regularly. He receives some special services. He's still struggling educationally because he got such a delayed start. He is in a pre-adoptive placement.
Thank you for letting us know about that situation. The substituting of judgment and your client's own wishes. It's helpful. Thank you.
Thank you.
Good afternoon, Justices. My name is Nancy Dietz, and I represent 4 of the children at the heart of this proceeding. I'm going to rest on my brief with the exception that I'd like to give you an update as to how my clients are doing. The 15-year-old boy, who is the son of the respondent father, he had initially been placed back in summer of 2023 with his paternal uncle and aunt. At the end of last school year in June, he was moved to the placement with his maternal aunt where his full biological siblings, the twins, are. He wanted to reunite with the older siblings. I met with him this week. He tells me he enjoys living there with his aunt, and he wishes to remain there with his twin sisters. He is back attending Chautauqua Lake School, which he has attended previously, so he's been reunited with his friends. He is well liked by his peers and his teachers. He is playing football for his school, and he had his first game earlier this week. He tells me his father did attend his game. He continues to see a mental health counselor. He tells me that he's been attending visits with his father and the parent substitute. And those are unsupervised visits for the older children. He also sees his younger siblings at supervised visits, although he does miss some visits due to playing sports. I also represent the child that had the hydrocephalus issue. He was 4 when he was initially placed in the foster care back in May of 2023. He has had a few foster home placements. His latest placement was in June of this year, and he's adjusted very well to that placement. He tells me that he very much enjoys being the only child in that home. His educational and medical needs continue to be met now that he's placed out of the home.
I remember he had significant medical needs.
He had severe dental issues, the hydrocephalus, severe delays, when
Has he
initially.
caught up?
He's getting there. He's been wearing leg braces. He went to Shriners. He got the braces, the wheelchair, the different devices he needs. And every time I meet with him, his mobility has improved. So he's doing well. He really is. He attended summer camp at the Y, which he enjoyed, and he tells me he enjoys attending church with his new foster family. I also represent the son of both respondents who's younger than the one I just described to you. And he just entered kindergarten at Sherman School. He and his younger sister were placed with the paternal uncle and aunt as well. So they've been there since summer of 2023. He tells me he enjoys school, he's making friends, and he enjoys his visits with his family, and especially being able to play with the brother that had the hydrocephalus issue. Those two are the closest in age. I also represent the daughter of the respondents. She was the child that went 14 months without seeing a pediatrician. And she had some developmental issues, and she was had a low. She was her weight was not where it should have been, but her needs continue to be met with the paternal aunt and the uncle, and she's doing well. So I'm respectfully requesting that this court reverse the determination that the respondent mother did not neglect the children and send the matter back to family court for disposition. I think there's so many areas that this woman was neglectful. And that's my position on behalf of these children. Thank you.
Thank you, Councilman. Mr. Monahan.
Good afternoon, Honorable Justices. My name is Todd Monahan. I will be briefly arguing for Emily Walker. I, as well, mostly will rest on what I submitted in my brief, but there are a few points I would like to emphasize while I have the opportunity. And of course, I'm also happy to take questions from the bench. As far as my client is concerned, and as far as I'm concerned, the most pressing issue before this court right now is the fact that these children have been away from my client, their mother, for in some cases in excess of 2 years. And this has done what I hope is not, but what I fear could be considered irreparable damage to the parent-child relationship. And in addition to what I would characterize as a moral injustice that's taken place with respect to that placement, I would note, as I emphasized in my brief, I think it sets a really poor precedent issue where effectively departments such as this could effect a removal as they had, and these proceedings then become dragged out. I mean, this is a nearly 6,000 page record. This case took place over the course of almost 2 years. At the conclusion of which, regardless of where the evidence points, the department then essentially presents the court with a fait accompli, saying, well, these children have been in foster placement for what the trial attorney characterized as an exceptionally long, unheard of period of time. And so regardless of where the evidence points, the children cannot be returned to the parents. And I think, I know, having spoken to my client repeatedly, that is her greatest concern, is that will she ever be able to, regardless of where this court comes down on the issue of neglect, which is a separate issue. But I think
And actually, counsel, I'm gonna just say that's the only issue before us is neglect. Whether or not the mother should also be found to be neglectful, all that other stuff you just told us, the other arguments you made, really were for a different judge at a different time.
Well-
You know, we don't get to affect what happens next in the permanency hearing. All we could do is promise you we'll get you a decision as soon as possible so we can.
There is I know there is a stay from this court on the placement order or on the return to parent order, so. But Your Honor, following up that point, and going off of what I heard from the other attorneys, in this matter, I think, 99% of the time when cases like this appear before an appellate panel such as this, the shoe is on the other foot, and it's the respondent's attorney or the parent's attorney arguing, the trial court was rendered a decision in error. The record does not substantiate the findings and whatnot. I find it odd that in a case where, like I said, this is a nearly 6,000 page record, numerous appearances, numerous hearings, trial dates, things that happened outside of the record that nonetheless were preserved on the record by various parties, alleged outbursts by judges, alleged conduct of social workers inside and outside of courtrooms that were not caught on the record. I don't know how it would even be possible for an appellate court to take a de novo review of this matter when the trial judge truly and literally was in the only position to review the evidence in this matter. That's become something of a legal bromide. The trial court's in the best position to evaluate the evidence. But in this case, I don't see how there's anybody else who could possibly have evaluated the evidence in this case. And like I noted, a lot of things in this case seem to have taken place outside of the four corners of the record. You have a very reputable and competent attorney going on the record saying she was threatened, she was intimidated. You have the allegation, I think it's pretty clear that you have the allegation that the social workers manipulated a criminal justice matter in order to leverage these parties. I think what this case really is all about, and I'll conclude on this point, is whether my client or not was neglectful flows from what I think is the most important issue, which is domestic violence. I know this was touched on briefly, but my client, Emily, as the record would indicate, is as much a victim in this matter as the children are. I think it's very clear, and she stated numerous times that she was the victim of abuse by James. She also has her own personal struggles, but that doesn't, the fact that she has those struggles doesn't per se equate to her being an incapable or a neglectful parent. I think it's tempting to look at James Murray and Emily Walker as this monolith, that if one was neglectful, one was at fault, then the other one must be. But I've tried as best as I could in my brief to make it clear that these were two individuals and they were two different parenting styles, and the one bears far more culpability for any negligence than the other one does.
I think I heard one of counsel say today that they're still together. Is that what your understanding is?
Judge, my understanding, I know they have the same mailing address because I've had to serve them both with various papers, so I can only speak to that. I am not aware of the status of their actual relationship, but they do have these children together, and I know that they have, in varying degrees, sought remedial help for these issues. My client certainly far more than the other one. But I don't see, I understand that this is a case where some of these facts are troubling, and I didn't shy away from that. I did, and counsel was correct. I did say I don't really take any issue with the findings by the witnesses in court. All I take issue with is the interpretation thereof. The trial judge issued a very detailed finding that he did not feel that my client, Emily, was neglectful, nor did he feel that she was ever treated in a respectful and professional manner by the social workers at this particular department. And I think the court really needs to look at that as well. I think the conduct of the lead worker, Miss Martin, was egregious. I think some of the allegations, and if nothing else, recommendations are not mandates. And there was an issue about whether these individuals were even properly served. It would be like you can't find somebody guilty of a crime if the prosecution has not abided by the due process requirements of the Constitution and statutory law in getting there. You can't find an individual to be neglectful if, for lack of a better term, it seems like the county had a predetermined outcome and manipulated this matter to get there all along.
Well, counsel, let me just say this. I think there's some objective evidence here. Forget about what the social workers might have been trying to prove. I mean, lack of providing medical care is pretty objective. Lack of providing dental care seems to be pretty objective. I think that if we just go to the objective, proof of neglect, and take away all of the maybe subjective proof, we're still, that's a lot of evidence that points to your client as being neglectful.
And Your Honor, what I submit in response to that is the explanation. The explanation is poverty. Not everybody.
Well, apparently too, they had the ability with Medicare to get the actual treatment for their children, and they chose not to. And they claim poverty, but they had the means. They had the financial means to obtain the services that these children desperately needed, and that failure could equate to neglect in itself. And as Justice Bannister said, we'll throw in educational too. How many days of school do you need to miss? You're failing. You're not pursuing it. You're not moving forward. And how do you not define that as neglect?
And Judge, the trial court, respectfully, the
I
trial
see that.
court,
I see what the trial court said. I guess we're here at this point right now to see whether or not the trial court got it right.
I see no reason to reverse the trial court. Thank you.
Thank you. Thank you all.